So we've had three separate regulatory regimes in the 10 years preceding today. Why not do it again? And it looks like we're ready to look at a new set of changes that are coming down the line here as well.
And that's where we are. So Title IX just turned 50 last week. And on the day that Title IX turned 50, the Biden administration proposed a new set of amended Title IX regulations.
So what's different with this set compared to the 2020 iteration?
Yeah, it's interesting. Now, I have to say, for where we are right now, the proposed regulations span more than 700 pages. So I think, like most of us who practice in the area of Title IX, we're still sort of trying to get a handle on 700 pages of new, proposed regulations. But I think what we can say is this: the Biden administration new regulations, I think, mirror in many ways the general structure of the current Title IX regulations, but revert back to many of the Obama administration ideas of a broader process, broader definitions of what constitutes sexual misconduct, and a more informal investigation process with an emphasis on sort of creating right outcomes that allow colleges and universities the flexibility to design a process that meets their particular program and activity needs while still satisfying Title IX.
So where does this leave us on the due process for the rights of the accused situation?
In an interesting spot in this sense. The proposed regulations allow colleges and universities to continue with this formal investigation hearing process if they want to. It's just that it's no longer a requirement as it was or as it is currently. So what you have, I think it's fair to say that you're going to find many colleges and universities will revert to the previous investigation process. Less formalities, less resources required, certainly less technical requirements than we were seeing under the 2020 Title IX regulations, while still recognizing due process rights for those accused of sexual misconduct. And I would say also, Tim, that I think what you're going to find is, because we were talking about this, that in the judicial review process, some courts have taken the position already that there are significant due process rights required of someone accused of sexual misconduct under Title IX, while other courts have taken a more lenient approach to due process and have allowed colleges and universities to define their own process as long as it's not overtly unfair to one side or the other. So you are going to have kind of a patchwork of enforcement moving forward. So it will be interesting to see where we land with this. We've got sort of incentive, I think, for most colleges and universities to return to a less formal process with less due process requirements. Yet, depending on where your college or university is located, you might find yourself subject to judicial review that may require more due process formalities than other colleges or universities located in other parts of the country.
So we've got changing definitions of the scope of sexual misconduct. We've got changes in terms of process around due process in these regulations. What's next in terms of the approval of these regulations?
From the date that they're published, there will be a public comment period of 60 days where interested parties will be able to submit comments on the proposed regulations to the Department of Education. Just to give you an idea of the level of interest that we anticipate here, back in 2018, when the Trump administration proposed the current regulations, the Department of Education received more than 100,000 public comments on the proposed regulations. I think the interest level is going to be about the same here. After 60 days, the public comment period closes, and then the Department of Education will take into consideration, we assume to some degree or another, what they hear from the public in terms of the proposed regulations. But I think based on what we know of the current administration and sort of the overarching goals, I think we can say that the final regulations, whenever that happens, will look a lot like what we see in the proposed regulations. At some point, the Department of Education will publish a final set of Title IX regulations, which will then, at some point, go into effect. Colleges and universities will have to come into compliance at some point with some amount of lead time, but we don't know what that is. For the 2020 Title IX regulations, the lead time was only a couple of months, and it was a very heavy lift for colleges and universities. We did a lot of scrambling to try to get ready, new policies implemented, and new staffing in place, training underway, which is a big deal, as you know, under Title IX, in a very short period of time, so that colleges and universities could come into compliance. There was no sort of good faith effort to comply. It was, you will comply by date certain. So we don't know whether that will be the case here, but what I think we can say is, because the new proposed regulations look a little bit more familiar to most of us in the Title IX area than the current regulations do. I think that sort of compliance will be a little less onerous, because everyone more or less knows what that process looks like.
So it's more reversion to earlier version, as opposed to having to develop a completely new set of policies and procedures.
It's an interesting combination of keeping this sort of general administrative framework that's currently in place, keeping that framework intact, but changing the scope of the applicability of the regulations, changing some of the definitions, and changing the level of formality that's required in the investigations to look more like what colleges and universities were used to before the 2020 regulations went into effect.